this is Attorney Mike Gravel coming to you from a partially disclosed location. Some of you might have been on Vlog Talk earlier today. I did a stream, kind of half outed myself. I spent the morning with monkeys and sloths. I got a little bit of that for you. I got about 20 seconds of that, and then I got a bunch of court clips from Zach, and I even have one from court with Chrissy. I might get that in. I don't know. I haven't seen any of it. I've literally spent all day either with monkeys or asleep. That's the truth of the matter. But I'm back, baby. Let's get this thing done, shall we? All right. I'm not in this video, but I'm taking it.
Don't leave them alone. Go ahead. Go ahead. Right. I want you to do this.
This is Kayla P.
For assault for the plaintiff.
Jill Bauer for Ms. P, Your Honor. I am going to enter an appearance this afternoon. Well, actually, five Monday morning to get out soon.
All right.
Kayla P.
All right. Where are we on this case?
Your Honor, Legal Services has not received any of the paperwork for this case yet. I requested it by email and haven't received it yet. Mr. Asphalt did say that he would get it to me, but this is a complicated case. It's
it's a fire unit.
It's a termination of tenancy case, and I need time to investigate and file either an answer or a motion.
But she's not in the unit right now.
No, she's not.
They filed a health claim.
Yes. She's zero rent.
But you're no longer in a Sycamore Meadows unit.
No, sir. They didn't rehouse me.
Pardon?
They didn't rehouse me.
Yeah, she's been unhoused since the fire on November 14th.
Yes, sir. And I signed my new lease on that same day before I discovered the fire.
And I've made requests for her to be rehoused and they've been denied.
Okay. When do we want to put it to?
I'd like at least 3 weeks to be able to go over all of this is very complicated. There's a lot of evidence and I want to.
You always tells me everything's complicated.
Your Honor, if the court wants to do that, I would request that she file some type of brief, laying out what the issues are, because I think it's pretty clear. And also, I think that in this case, an escrow order would be appropriate.
She's zero rent.
Pardon me?
Her rent is zero.
Right, but I mean, every month that we can't use the property, it costs my client money. And it's also causing, even more to the point, it's causing.
So hold on, counsel. If her rent is zero, and you want me to set escrow, what would I set her rent? What do you suggest?
Yeah, I guess
set the escrow rent?
I didn't realize that her rent was zero. I think my client is more concerned about the damage that is accumulating to the property that's just sitting there in the severely damaged position that it is in. And if she's not even living there, I really don't understand. I mean, this case is just about possession. She doesn't want possession of that unit. In the meantime, somebody's paying for this unit. I mean, we're not seeking a money judgment. It's
Well, why? Then explain to me.
if they feel that she's entitled under the lease to another unit, then they should file some type of action stating that. And if she's been entitled to it for the last 3 months, then maybe my client will have to pay, although if her rent's zero. But my point is just simply, Judge, I don't understand. This case is about possession. She's not in possession. She doesn't want possession. It would be better for everyone.
No, I think she wants to be housed.
Yes, Your Honor.
Just my thought.
Yes,
So she wants to be housed, can't live in the unit that she's in.
correct.
And so therefore, she probably wants a unit.
Yes.
Right, but what does nobody wants possession of the burned unit. If they feel like they're entitled to another unit, then
But,
they should file
but
something.
hold on. If she surrenders possession, then in essence, she's giving up her right to any unit. That's what the problem is.
Yes.
So I get why it's where it is. So, has it, the basis or what happened with the fire, tenant's fault, landlord's fault, or undetermined?
Your Honor, I believe even though the fire report says that her cat started the fire,
Her cat.
yes, I examined.
Her cat?
She was not at home.
Her cat
Her
started.
cat. I examined.
That's why I've told my cats always stay away from cats.
Then
I don't.
Oh no! I don't have my cat jumped on his wiener clip.
Don't let them play with lighters. I just keep them all in one spot because they could do that. I'm kidding.
One of the things that I want to investigate is how reliable that report is, because the stove that she had, and the knob has to be pushed in and turned. I don't believe a cat could turn on this stove.
Whoa.
So I think there's a problem with the theory of how the fire started. And Miss P was actually at the office doing her research for 2 hours while the fire started, so she wasn't home.
While the cats were turning knobs on.
Yeah, yeah. So there are issues with the theory of the case, and it's going to require some work to get a handle on our.
Okay, so I see.
Yeah.
So
Judge, I mean, my client would be willing, I mean, if she's talking about now like hiring experts to a stove, I mean, if the court just brought up the issue of if she gives up the right to possession of this apartment, then she's giving up the right to claim that they have the obligation to house her in another apartment. I mean, we'd be willing to waive that argument. And if she wants to file a separate pleading, to go delve into whether or not we have the obligation to house her in a separate unit that can be preserved. But in the meantime, so the taxpayers aren't continuing to pay for a unit that's vacant and continuing damage to this unit that she clearly doesn't want and isn't living there. Give us possession of that unit, and then we can go forward with this idea of, is she?
why hasn't
entitled
Sycamore
to-
Meadows just gone in and repaired it?
Exactly.
And then decide
Well,
who
we
has,
can't. I mean, if
why
she's-
can't you?
if she's willing to, because I mean, that's essentially taking possession of the property, Your Honor.
No, it's
I
not.
guess if the court's willing.
It
to
is
enter-
absolutely not. It's not the same.
All right, if the court's willing to make the ruling, I mean, obviously, we normally always want an order
I think this attorney's actually making sense here.
allowing us to go in unless the defendant has turned in her keys and given us permission. But sometimes on the record, if she's willing to state that it's okay for us to go in there and take possession essentially and start making repairs, that would be.
Why can't the parties stipulate to allow the repairs to the premises?
Your Honor, we were never asked to, and actually, one of the issues is they've been they've given her 1 hour to remove all of her belongings from the unit. Once she has her belongings out of the unit, or if they can work around her belongings, the fire was only in the kitchen area, we would be happy for them to repair the.
That's fine, I'll prepare an order.
Everybody is making this harder than it has to be.
I'll prepare an order, giving her a certain amount of time to remove everything she needs out of there. And then after that time frame, my client can go ahead and take possession. Can we have a 1-week adjournment just to make sure that we're in agreement with that order?
Your Honor, we're not agreeing to them taking possession. We're in agreement with allowing the repairs to begin.
Well, I mean, yeah, I guess.
You guys
it's
are never
semantics, but I
gonna
mean,
be able to
I think
agree.
she has to get everything out of there, right? Before we can do the. repair.
Right, but I remember this, they were giving her a very small window to try to get stuff out and putting a number of different restrictions on her entry, or at least as she perceived the instruction she was getting. I don't know if it was
No,
true.
they were
Right. I
restrictive.
think that has something to do with, because like the county says nobody can go in there. So I don't know. I guess I'll have to talk it over.
January 31st, 2025, 12 noon.
Your Honor, I just want to get clarification from the court that that's not going to be the deadline for me to file a response, correct? Because I don't have any of the
You
paperwork.
want it to be the deadline?
Pardon?
Do you want it to be?
No, I would like-
Did I say it was the deadline?
No, I just
Then it's
wanted-
probably not.
Okay, thank you, Your Honor.
And make a note.
Don't be landlord people.
I'll text you. Okay, all right.
Good bacon peeps.
Let's see if we do that. Jarrett Lepic versus Andrew Elliott. And
All right. Zach sent me a note. He said it's not the greatest hearing of all time, but the chair is fantastic. And it sure is.
well, Jared Lepic and Jordan Lepic versus Andrew Elliott and Traversia, is it Burrell?
Traverso Borelli. TikTok says I gotta do a brand advertisement thing. This is starting to look a little problematic. We better finish that soon.
And I think I have.
Oh, good Lord.
Okay. So plaintiff, how much are you claiming?
I think that Zach's work there. Apparently, we're dealing with a TikTok influencer. Back in the day when TikTok was still up, it didn't take much.
The defendants, oh.
We are asking for $21,285. On top of that, we would like to demand for probation.
I'm not here for a bag. I'm here for free stuff. I do get a cut, full transparency. It's just not enough for me to care.
And a money judgment for
How much are you requesting in rent?
$21,285.
How much is monthly rent?
Well, Taversi, it's your lucky day. You got a whole new audience now.
$5,000 with a late fee of $1,000 not paid after the first, $2,000 late fee not paid after the seventh.
Okay, I can tell you right now, those late fees are illegal. So how much,
That is it. That is in our lease. So this was
I understand it's in your lease. I'm trying to let you know as gently as I can right now that I'm not enforcing that late fee.
So, in your honor, I totally understand. This was not actually intended to be a lease. They had purchased the home and the house sale fell through 2 days before we decided, or before we went into closing, and they had asked to move in. We said, if you pay the mortgage, we drew up a lease based off of them purchasing the home. And this is where we're at. So what happened is then they just stopped paying. And now
How much do they owe in rent?
So it was a $5,000 for 4 months. So that would be a total of $20,000.
And Your Honor, we're asking that February be paid since our lease was a 4-month term. And they have not paid a single payment so far.
And we also missed out on listing the home again because they have refused to not leave.
We've gotten screenshots of proof of funds. We've also been told that ACH has been sent. We received a tracking number at one point that actually never registered with the U.S. Postal Service. And so there's been a lot of like, we're going to pay, and we have yet to receive anything.
Okay, so I can do nothing with February because February's not due. That's the first thing.
If they're still by then, how does that work?
There
If
won't
what?
be. We're leaving. We'll be out by the 1st.
Okay, you say you'll be out by the 1st?
Correct. Yes.
How come not by next week then, if you're leaving?
I was told in text messages from Jared Lepic that we have until we can finish out the month.
So
If
you'll be
paid-
out by the 30th. You'll be out by the 31st.
Right.
And you will give them keys?
I
Look at this. I mean, this is what we've created in this country. This sense of entitlement. Just you can just do whatever you want, even though you're not paying. It's a mess. It's a mess. And everyone says I'm cranky, but live through it. Do that. You pay a mortgage while somebody else lives in your place for free and gives you the middle finger, and then tell me how you feel about it. Give it a try.
I can arrange that. Yes.
All right. So here's what we'll do, because there are two issues here. One is going to be the money. One is going to be possession.
Mm-hmm.
So I'm going to adjourn this out to the 31st, 2025 at 12 p.m. That will be in person in the court. I'm going to expect that if you have not surrendered the keys, that you will be in court and in a position to surrender keys to the Lepics at that point.
Okay.
Then we'll look at what money's there, because then that doesn't run, and we'll figure out what's owed and how that's going to be paid.
I will say we're moving to Seattle, Washington. I will make plans to appear in court in person, but depending on what our living situation is, then it might complicate my ability to show in person. What is there any recourse?
And you need to get them the keys.
Oh, I can easily get them the keys regardless.
Okay.
So
They
we are
need the
located-
keys.
It'll be before the court.
Before what?
Before the court that is being adjourned.
Okay. And then I may permit you to appear via Zoom if you're out of state,
Okay.
but they need their keys.
Of course. Thank you.
Sir, we are also located out of state. We're currently living in North Carolina.
I'm sorry to hear that, but no, I'm kidding. I'm just an old Maryland guy that doesn't like North Carolina, but I really do. It's actually a nice place. Okay, so everybody's out of state. So, ma'am, how are you going to get the keys to them?
They had someone come and give me a new key when they locked me out of the property. There was an illegal lockout that I was subject to. I've got one key that I can return.
All right, I want the key returned.
I can do that.
And then once the key's returned, then both parties may appear via Zoom on the 31st, and then we can figure out the rest of this.
That sounds great.
But I want them to have possession
Of the key.
of the key, which will give them possession of the premises.
Right. Okay, thank you.
All right?
Yeah, we have a manager that they can get the key to.
All right, that's fine. Then everybody can appear via Zoom. So I'll see everybody on the 31st at 12 noon.
Okay, thank you.
Thank you.
Thank you. Is that it? All right, 14A stands in recess.
Butler County Probation Review Docket of January 24, 2025. I'm David A. Ricky, District Judge. First case that I think I'm going to address on this docket is State of Kansas versus Mark Anthony Carter. Case number 2023 CR 194. Amber Norris appears for the State of Kansas. Chris Pate is defense counsel. Mr. Carter, where are you currently located?
In Wichita.
Why are you not at the Judicial Center as you were ordered to be?
I just found out about the court today at lunchtime at right at 12 o'clock. I did not know that the court date had been moved up, Your Honor.
Okay,
And also,
Wichita
I
to
was
El
just-
Dorado is about 45 minutes tops.
But I called
And
my
you're off,
attorney.
Mark, can I help out here, Your Honor? This might be my fault. I know he was arrested in Sedgwick County, bonded out. They gave him a court date in February, and then it was advanced to today. Mr. Carter called my office a couple hours ago. He told me he was going to have trouble getting out to El Dorado in time. I told him it was set for Zoom. I did not have anything in my file that showed he was ordered to personally appear at court. So I instructed him that Zoom would be acceptable, not being aware there was any prior order.
Almost every defendant on a warrant to show cause docket is ordered to be at the Judicial Center in El Dorado, or Eureka, or Howard, whatever our courthouse is where they're conducting the hearing. So it's a rare exception rather than the rule that they participate remotely. But Mr. Pate, I appreciate your statement. Let's proceed further. The allegations before the court is that on September 23 and October 20,
The judge is rightfully annoyed, and the attorney did the right thing, just jumping on that grenade for his client. I understand both of them.
23, 2024, the defendant submitted urine samples that tested positive for amphetamine, methamphetamine. Number 2, the defendant failed to make any payments toward his court fees and restitution, current balance remaining $25,512.99. What are your client's intentions regarding these allegations, Mr. Pate?
Your Honor, while he does want to offer some explanation as to the violations, he's prepared to admit those and then proceed to disposition today.
Mr. Carter, you do have the right to a due process hearing where the state has the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, confront the state's witnesses unless good cause is shown, and among other lesser remedies, the court could consider just an outright revocation of your probation and ordering you to serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, I do.
And do you waive a hearing and stipulate and agree that you committed the positive urine sample and failure to pay violations as alleged?
Can I give an explanation?
Later.
Okay. Yeah, I mean, I did make payments to the Wichita area because they told me I had to pay these over here first whenever I was on, because it transferred my probation over to Sedgwick County. And I was told that I needed to pay that over here first. And then I'd been paying on it. And I just, and the rest of it, I took medicine and it violated me. So there's no denying that, I guess.
Medicine?
Yes, sir. Sinus medicine. I've had all
medicine caused you to be positive for amphetamine and methamphetamine?
That's what they were telling me, because I quit taking the medicine and everything was cleared up. I submitted clean UAs all the way up until that point, and then after that, and then we figured out what it was when I went to the treatment. I even did the treatment education like I was requested to do, and I went through that successfully. I graduated that. I have a certificate for it, and they were telling me that the medicine would do that, and I stopped taking all the medicines, and all my UAs have been clean since then.
All right. So
I'm
are you
working.
admitting these violations or not?
Yeah, it's obvious that they were violated because I went back and read my court orders and stuff and the probation stuff, and I wasn't supposed to be able to take those medicines, and I didn't realize that at the time. I do apologize, but yeah, I did violate because of that.
The court finds that the defendant has waived hearing and stipulates and agrees that he's committed the violations as alleged in the warrant to show cause. The court finds these to be significant material violations of the terms and conditions of his probation. We'll now turn to disposition. Mr. Ketley, perhaps I'm going to start with you because you've got extensive experience in the supervision of various offenders. The allegation that mere over-the-counter medications, and I'm presuming these are over-the-counter medications, can cause a positive test that you take, that you administer for amphetamine and methamphetamine. Is there any precedent for that in your view?
Not that I'm aware of, Your Honor. I mean, there are some medicines like Ritalin or whatever make you test positive for amphetamines, but not methamphetamines. The levels were over 10,000 nanograms for methamphetamines. And that's normally methamphetamines.
Obviously, I'm quite interested in the state's position on this case. Mr. Ketley, do you have any personal recommendations regarding an appropriate sanction or disposition here?
Well, I believe just based off the fact that he tested positive and he has since completed treatment. So that is true that he has completed treatment since then. The UA was back in October. I would get, this would be, well, it's his first violation, I'm guessing. So we probably, he'd have to serve some type of jail sanction, I would believe, Your Honor.
All right. Thank you, Mr. Ketley. I appreciate the information. Ms. Norris, your position here.
Your Honor, state would be recommending 2 days in the county jail as a sanction. I do believe we're at the stage where we need to begin the DIP process. This is the first warrant to show cause. I do believe that the court would need to do an extension. He was initially placed on probation for 12 months with community corrections. And that was on January 2nd of 2024. So I do believe that he would need a 12-month extension from today's date. And Your Honor, I don't know what the defendant was referring to when he was saying something about payments over in Sedgwick County. I think he is courtesy supervised, at least to a certain extent. But he has, as far as I can tell, he has made 0 payments on this case. And obviously there's a significant amount of restitution. And it's my understanding that he basically told his probation officer that he wasn't going to pay it because his case was on appeal. And I would know for the court that the court did not allow for an appeal bond. So all orders are still the same and that the defendant needs to follow all of them. So like I said, I don't know what he's talking about with the payments. Mr. Kelly and I did have discussions a little bit about what's been going on with Mr. Carter. But he had actually even contacted me back in September, basically asking about the payments, and that, you know, he was ordered to pay $250 a month. And basically he was not making those payments. So obviously I think that's something that the court definitely needs to address at this hearing. And Your Honor, additional court appointed attorney's fees and the bids application fee as Mr. Pate was reappointed for this hearing. Thank you.
Very well. I'm going to go back to Mr. Ketley. Is there some sort of fee that's charged by a courtesy supervision office, such as
I just downloaded it. Zach might have sped it up a little bit.
Sedgwick County's Community Corrections Department?
Yes, they charge $450, and it's just a fee for everybody that's on our program, whether they're a courtesy or a Sedgwick County case.
Is that something unique to Sedgwick County?
No, we have $125. And almost every district in the state of Kansas charges some type of supervision fee.
Right. So despite the fact that he was charged a supervision fee over here as part of his original sentencing, Sedgwick County charges him $450 over there?
Correct.
All right. Thank you for that information. Mr. Pate.
Your Honor, we would ask the court reinstate. I think an extension is appropriate in this case. I do think the maximum that the court could give under the state of the law with the first PV in this situation would be a quick dip. We are asking for a reinstatement. There were a couple positive drug tests. I don't think Mr. Carter's offered his explanation. I don't think I need to get into that anymore. He admitted to it. He entered into treatment. He successfully completed it. Every UA since then, my understanding, has been clean. So that issue appears to have been resolved. He does have employment at King of Freight right now. He reports he's making about $2,000 a month. He's got 4 kids at home. So money's pretty tight, but he understands he needs to start making payments. And I think the whole...
Well, Mr. Pate, I'll just interrupt you there. He was ordered to start making payments a year ago. And he understood then he had an obligation to be making payments. So what's different now? I mean, apparently he hasn't paid anything on the Butler County obligations for an entire calendar year. Would you agree?
Other than the restitution, it appears so, yes. It sounds like he had to pay that courtesy fee before anything would be applied to it. He's now employed. He's had a few months of employment. He understands he's going to need to get this paid off. I think it'd be beneficial to the victims to extend this and give them time to do that. We know it needs to be paid, Your Honor.
How much are your fees on this round of proceedings, Mr. Pate?
They'll be probably $200.
Well, hell yes. The kids are what caused the meth problem.
All right. Thank you for that information.
I mean, they didn't cause it. It's not their fault. But you know, if you ever had kids, you'd understand.
All right, Mr. Carter, at this time, the court will address you personally and ask you if you have any statements that you wish to make in mitigation of punishment here.
Yes, Your Honor. I'd like to just say a few things that, I'm money is tight right now, and I've never, what the prosecutor was saying with my probation or whatever, my probation officer in Wichita, I've had 3 or 2 of them over here since the start of it. I've been switched from one to another, and then I'm back with Mr. Ketley now. But I never stated anything like I'm not going to pay it or any of that. I did say it would be nice not to have to pay it because it's on appeal, but I wasn't granted that by the court, and I have to pay these fines over here, but I just can't afford it at the moment, is what I was explaining to my probation officer. I don't think she understood my whole explanation of that. And then on the other note, I understand that the first probation violation, this is my very first one. And since then, I've straightened out everything that was in my system. It's no longer there. I did the recommendations. I'm working, and I'm barely paying the bills right now, but I got my feet in the door, and I got a good job, and it's going to work out. And the money I'll start making more money here shortly. It's just through these winter months. It's based on sales and hourly pay, and my hourly pay is about where I'm at each month at the moment at $12.50 an hour. But it should pan out to be more than that, so I can start making payments to them here. Hopefully by the end of this month, going into next month, I should be able to start making payments because I can only get a commission check once a month, and I haven't started getting commission yet. So that's about all I got to say, Your Honor.
Very well. For the violations that the court has found earlier, the court will order the defendants to serve 48 consecutive hours. In other words, a 2-day quick dip in the Butler County Jail starting at 6:00 p.m. this evening. So, Mr. Carter, you've got approximately 3 hours to get yourself to report to the Butler County Jail in El Dorado, Kansas, just east of town. I think you're familiar with the facility. To serve your 48 hours or 2-day.
A quick dip. It almost sounds like fun.
Quick dip, which the court has imposed. And then the court will reinstate the defendant's probation. All unsatisfied conditions remain to be satisfied. And the court will expect regular and consistent, in other words, monthly payments on the obligations that are owed in this case. Court will extend probation in this case for 1 calendar year. The original probation date was started January 2 of 2024. The court will extend probation at this juncture to January 2 of 2026, subject to further extension if necessary. Under the financial circumstances which currently exist, the court's not inclined to add additional amounts at this stage of the proceedings. So any bids, assessments for this round will be waived. Ms. Norris, are you aware of anything further that needs to be addressed regarding the Mark Carter case at this time?
I don't believe so, Your Honor. Thank you.
Anything further from your perspective, Mr. Pate?
No, Your Honor.
All right, Mr. Carter, again, I'm sure you've heard all of the court's orders. Your probation's been extended after you serve this 2-day quick dip in jail starting at 6:00 p.m. this evening. And I'm going to direct the community corrections officer that if he doesn't report, as the court has ordered, to file another warrant to show cause. Any questions about that, Mr. Carter?
No, sir, Your Honor.
Very well. Then the Mark Anthony Carter matter will currently be in recess, and we'll move on to another matter. Mr. Favre, we're going to take up your case next, which is State of Kansas versus Victoria Lorraine Williams. It's case number 2024 CR 28. Joseph Favre does appear separately from his client by Zoom. Victoria Williams appears from the Butler County Judicial Center Zoom location. Amber Norris on behalf of the state. This matter came before the court in July of 2024. At that time, the defendant stipulated to violations. The court ordered an outright revocation of her probation and ordered her to serve the remaining balance of her 6-month sentence in jail. Later, however, based on a request for the court to review that sentence and request essentially for parole, this court did grant a report.
Okay, who's the defendant here? Top center? I can't piece this one together yet.
Reporting parole of 1 year on October 23 of 2024 with the requirements that she observe the law, report to her CSO as directed, not have any alcohol or illegal drugs, and pay off her case. Court did note that there were no other conditions. We have a warrant to show cause, which has been filed by Ryan Smith, the supervising parole officer in this case, that she failed to report as directed, failed to pay as directed, and failed to refrain from illegal drug use. Mr. Favre, what are your client's intentions here?
So, Your Honor, I think regarding those allegations by Mr. Smith, I spoke to Mr. Smith earlier today, and I think he told me she was reporting. So I think that one is maybe not on the table anymore, but she would stipulate that she did test positive for methamphetamine on when tested by Mr. Smith, and also has not paid off her case yet.
What is the explanation for her failing to pay off her case, Mr. Favre?
Judge, I think it's a combination of things. She is spending significant amount of money to try to keep up her household. She babysits grandchildren. That takes up time. Her boyfriend.
She spends a lot of money on meth.
long-term boyfriend, Mr. Westbrook, has significant health issues. She has been having work sporadically, but she's working now, and she is working 2 jobs, taking care of him as well as working construction jobs. So I think she's just had, a lot of time trying to get her house in order financially, as it were.
All right. But nevertheless, it is your position that her position will be that she has violated that term and condition of parole.
She has not yet. That is correct. She has not paid off her case yet, as is required by the court.
All right. Thank you for the additional information, Mr. Favre. Mr. Smith, I suspect that at the time you filed this warrant to show cause, you were of the impression as a court services officer that Ms. Williams was not reporting as she had been directed to do. Is that a fair statement?
Your Honor, she did miss one appointment with me. That appointment was an appointment for her to come in and pay for a confirmation test. That is the one appointment that she did miss since her reinstatement.
All right. So Mr. Favre is certainly of the opinion that she is reporting as directed since that time?
She has, Your Honor. Yes.
All right. Thank you for that confirmation. All right, Ms. Williams, this is a misdemeanor parole case rather than a misdemeanor probation violation. They are not the same, but they're close in character. So generally speaking, I would believe you would have a due process right to a hearing where the state has the obligation of proving these allegations by
Same, but different.
preponderance of the evidence. You could challenge the state's evidence with your own evidence and with the assistance of your lawyer, confront any witnesses unless good cause was shown. And of course, I think you realize that the court could just once again order you to serve the remaining balance of this jail sentence in the jail. You understand that?
Yes, Your Honor. Yes, Your Honor, I do.
So do you waive any formal hearing in the case and stipulate and agree that you committed the positive test for methamphetamine and the failure to pay off the case?
Yeah, I admit I haven't paid off my case. I just got working where I'm actually getting paid and not just doing it because I have to do it. I did test positive, but it's not for the reason why you all think. It's not that I was using. It's not that I am using. I learned about meth residue and dermal absorption the hard way.
Oh, shit. Here we go. Meth residue and thermal absorption. It's not because I was getting high. No. I know it looks like that, but no, it's thermal absorption. Let's hear it.
I've smoked meth in my home for 3 years. Everything in my home was contaminated. I had no idea of this. I had to buy a substance that would actually help break down the meth residue before I could actually even get my home clean. I informed Ryan of every step that I took through this whole process. I let him know exactly what was going on with everything. I did finally get my home clean. Got everything repainted and washed and everything broke down. But yeah, I did. And I informed him that I was going to test positive for the next test that I took because I had been doing all the cleaning, and I told him my levels were going to be high due to the amount of cleaning I'd been doing. And it was really nasty, and it was really mortifying learning about it. It was, the ramifications of an addiction are still haunting me.
Mr. Smith, do we have a lab confirmation of the positive test for meth?
Yes, Your Honor, on 2 separate occasions.
And your assessment of the levels?
Your Honor, I believe that
Your voice is very faded at this point, Mr. Smith. I just want to make sure everyone can hear you.
So the first test, I believe, Your Honor, was 298 nanograms per milliliter. And then a subsequent test about 3 weeks later, 3.5 weeks later, it had jumped from that 298 nanograms to over 2,500 nanograms per mil.
All right. The court will find at this point that Ms. Williams has waived a hearing knowingly and stipulate and agrees that she's committed both of the violations that remain in this case, the positive test for methamphetamine, obviously connoting use of that illegal substance, and not paying off her case. These are substantial and material violations of the terms and conditions of her parole. Recommendation by the state regarding disposition here.
Your Honor, this is defendant's second warrant to show cause in this case. As the court recalls, we were here in July and the court actually did revoke the defendant and place her in the county jail. She wasn't there for approximately 32 days. And then the court did place her on parole. And here we find ourselves back before the court for additional violations in the case. At this point, Your Honor, the defendant has 33 days of jail time credit. And we would be suggesting to the court that the defendant's probation be revoked outright and that she serve 4 months in the county jail with credit for time served, which would be basically 2 months off of the 6 months that she had originally been sentenced. And then the court closed the case and the money to go, money still doing it and go to collections. She's obviously not doing very well on probation / parole. I think maybe there's been a slight improvement from before, but still without, not making the payments and still using, that obviously gives state cause for concern.
I understand your position, Ms. Norris. Mr. Smith, would you have an independent recommendation to make to the court today?
No, Your Honor, I would not.
Thank you.
I agree that her attitude has improved since being placed on back on the parole, but obviously the tests show that she still has methamphetamine in her system.
Mr. Favre, your recommendations regarding an appropriate disposition here.
Judge, this is her first time on parole revocation. Ms. Norris correctly states that she was previously revoked once for probation, as the court also noted. She has had a really hard road, but I think she has shown some promise. She had another case that was pending that she has taken responsibility for, has entered a felony plea, and that is going to be set for sentencing. It is set for sentencing the next, I think, month and a half. Ms. Williams is working, as she noted. She's also taking care of a boyfriend that has very significant health issues and is currently receiving medications through a PIC line. So she's got a lot of things going on in her life that would be disruptive not only to her but to other people. She is essentially being violated for her substance abuse struggles, and I'm not qualified enough to.
I'd test her for whatever medications he has. Call me cynical.
Make a claim on this dermal absorption claim of hers. I know that it's possible to have skin contact absorption. I know that.
I got your dermal absorption right here.
Much. I don't know if it's enough to justify the levels jumping, and I understand the presumption of Mr. Smith and the state that that level jump is not going to be because of dermal absorption, but because she relapsed. But I feel like she's been pretty honest about her usage lately, and she has been reporting regularly to Mr. Smith. So we're asking the court to consider giving her an intermediate sanction and releasing her on probation. I'm not sorry.
I mean, look at this poor guy. I think he's a good attorney and he's doing a good job, but look at the position he gets put in. He starts with, I acknowledge that this whole dermal absorption story doesn't explain her test results, but other than that, I think she's pretty honest. Sweet Jesus. What else are you going to say, given these facts, if you represent her?
Back on parole to finish up with an order to do treatment, perhaps. The previously the court not ordered to do treatment. We'd ask the court to consider that. She obviously needs it. In the alternative, we'd ask the court to consider house arrest for whatever sanction it deems appropriate. Miss Williams is willing to pay for that house arrest, and that would allow her to continue to take care of her ailing long-term boyfriend as well as her other duties around the house. So that's our request at this time.
Thank you, Mr. Favre. Ms. Williams, at this time, the court will address you personally, and I'll ask you, do you have any additional statements in mitigation of punishment or anything further that you would like to present?
First, Mr. Westbrook is not my boyfriend. He's my best friend, but I just want to make that clear. He is not my boyfriend. He does have a lot of medical problems right now. He currently has a chest tube in him that's draining the bile from his body due to septic arthritis. He needs to have his gallbladder removed that's leaking into his body, and we can't do it because we can't keep his heart rate and his blood pressure up high enough at the moment. He is just recovering from being in the hospital for the last 2 months with septic arthritis. I do have to administer PIC line.
This reminds me of the video I did recently where the judge flat out asked, did you have sex with him? Which is what I know he's not going to, but I really want Ricky to say, okay, just for clarification, have you ever had sex with this guy?
Antibiotics 3 times a day to him.
Because that's what the rest of it means.
I do everything for him. He can't hardly walk or nothing no more. I would ask the courts to please consider house arrest in this case. I have no problem going and taking a drug and alcohol evaluation and following recommendations with it. I have been staying clean. I regret that it was in my home. I am working now finally. I did get a job with Hurley Construction and Landscaping. I do a lot of their foreclosures and clean outs and removals for them. So I am finally making money. I will be able to pay my fines off. So I just ask that if you would please put me on the house arrest. That way I can continue to meet my obligations on the outside. I mean, I leave it at your discretion.
What
Thank
about
you.
your obligations here?
Your Honor, I mean, I'm trying. I am working 2 jobs now. I am getting paid for working for Mr. Westbrook now. And I also am working for Hurley Landscaping. So I will be able to pay the fines off now. I didn't have financial stability before. I do now. I've been working 2 jobs for about a month and a half now. I babysit my 4 grandkids for my daughters when they're working. So I do have income coming in now, which has been a big relief off of me. I just had to catch up a lot of personal bills and bills at the home, the electric mortgage and all that. I probably should have made payment on my fines. I admit that, but I am working now, so I can get them paid off very quickly, next 30 days.
Ms. Williams, I do recall the hearing back in July of 2024 when this court ordered an outright revocation of your probation and ordered you to serve the remaining balance of 6 months, which was virtually all of it at the time. I know how distraught you were at the time. This court, when you were called back into court on a request that you had made, essentially the court then acting on that request granted you parole, which quite frankly, this court doesn't do in every case. And again, very frankly, rarely granted you one of those special exceptions, kind of like how the presidents are handing out pardons right and left here in the last month or so. It's a special release from a sentence that's been ordered and a probation that's been revoked. And I thought that I impressed upon you at the time just how important it was that since you were given truly a second chance. I mean, you were ordered to serve it all, then you were released from that sentence early on conditions. I pared down those conditions very specifically to just 4 conditions that you had to meet instead of that whole laundry list, which probationers generally have put in front of them to try to set you up for success. And I would have thought that you would have been so thankful about getting that second opportunity that you would have made every possible effort to comply with those parole conditions. I have had some success with parolees on misdemeanors really seeing the light, realizing how close they were to serving an entire long jail sentence. And then they take advantage of that second opportunity, and they are model persons who report to court services at that point. Well, that isn't you. The payment thing I know is difficult for someone who struggles financially. But what I would have expected from you is a regular and consistent effort every month. If you couldn't pay 50, you pay 5 or 10, but you pay something to let the court and the court services department know that you're making an effort, that you're carving out something toward your case. But that's not the most important thing here. I'm extremely disappointed that you would ever have a positive methamphetamine result. And quite frankly, Victoria, I don't buy this whole skin absorption thing. You used methamphetamine. It's a dangerous street drug that you have no business being around. And here you are with responsibilities toward children and apparently a man who relies upon you for some sort of medical and care assistance while you're using meth or you're around meth. And that those two are inconsistent in the court's view. You have not been successful on parole. But with that said, this court had entered an order earlier today in a case that has some similarity to this one. And even the state, and I think it's a very magnanimous thing that Ms. Norris recommended here to actually recommend a modified shortened sentence, which she certainly doesn't have to do. But she did here, and the court's going to grant that relief. But it's going to be in the same way that I did that for the earlier defendant in the case. Ms. Norris, it's my understanding she has 33 days of prior jail time credit. Is that
correct, Your Honor?
All right. I'm going to reduce the sentence in this case to 93 days and order Ms. Williams into immediate custody of the Butler County Sheriff's Office to serve the remaining balance of that 93-day sentence. She apparently has 33 days. 60 more days will be served by this defendant without release privileges as a sanction for noncompliance on the structured parole that this court had earlier ordered in this case. At that point, her sentence is flattened. If it hasn't been sent to collections, the court will declare any unpaid amounts to be immediately due, payable, and collectible. Ms. Williams, you're going to need to take care of those. They're not going to go away.
Yes, Your Honor.
Collection agency, you're going to owe even more. But that's the complication you caused yourself.
Okay.
The court is not going to add any additional fees for Mr. Favre's services at this round. I think that it just would be non-productive. And so the court will waive any additional fees for this round of proceedings. Ms. Norris, do you need any further clarification regarding the court's order made here today?
I don't believe so, Your Honor. Thank you.
Mr. Favre, anything further?
No, Your Honor, thank you.
All right, then I'm ordering Ms. Williams into immediate custody of the sheriff's representatives until she can be transferred to the jail to serve 60 more consecutive days in incarceration. And then her case will be flattened and closed. If there's nothing further, then the Victoria Lorraine Williams matter will be in recess. Ms. Norris, according to my sheet, that's the last case to be addressed on this docket. Would you agree?
I agree, Your Honor.
All right. Thank you all for your patience and your appearances here today. This will conclude the probation review docket, and this meeting may be ended for all at this time.
Mr. Elhart has moved the Fox case. I'd like to call that, it's set for 10 o'clock, it's 10:05. This is file 23-2155 FH, or FYI.
Mr. Chamberlain, one more document.
Thank you.
This one's from court with Chrissy. I have no idea what's going on. As usual.
Okay, so Ms. Trask, are you still there?
Yes.
All right. So this is a probation violation hearing. Mr. Elhart, you've been retained now to represent Mr. Foz. Are you prepared to go forward with a hearing this morning?
Yes, sure.
Okay, so Ms. Traska, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth? So help you God.
I do.
All right, and if you could please start by telling us your name and how you're employed.
Amanda Traska, probation officer for Leelanau County with District Court.
Hang on just a moment, Mr. Elhart.
If I may, Your Honor, Mr. Paz is here to admit that he is unable to do the community service work.
Okay, so he wants to enter a plea.
Yes.
What about the added violations for let's see, failed to continue counseling with the cancer center, disrespectful to court employees and care providers, and acting in a threat, intimidating, harassing manner.
Excuse me, patrol office sent. Yes. They sent a letter to my providers. When I found out about that, they didn't ask my permission to sign a release. That's right. When they found out about that. Yeah, you'll admit that.
Okay, so then, Mr. Foz, is that correct? You're changing your plea in this case to guilty of the violations. That's what you want to do, is plead guilty.
That's his direction, yes, sir.
Okay, so it's still your decision, but I understand you've consulted with Mr. Elhart, and that's what you've decided to do.
Yes, sir.
Okay. So before I take your plea, I want to make sure you understand that you do have a right to a hearing at which Mr. Elhart would represent you, and you're choosing to waive that right, correct?
Yes.
Do you also understand that the worst that could happen is for this conviction of leaving an accident causing injury, is you could be sentenced to up to a year in jail?
I don't understand that. I thought we'd already been through that.
Well, that's the worst thing that could happen. Do you want to talk to your attorney some more about that?
By violating probation, the worst thing that can happen is the maximum.
Okay, so you understand that, correct? Okay. Has Mr. Elhart answered all of your questions to your satisfaction?
Yes.
And no one's used any force, threats, coercion, or made any promises to you to get you to waive your right to a hearing this morning, have they?
I'm going to say no, sir.
Report indicates you were placed on probation back in October of 2023 for
There you
leaving
go.
the scene of an accident
That
causing
was a
an
slot from
injury.
today.
And as a condition of that probation,
There were a bunch of them.
you were to complete 30 days of community service work.
And every
for
last
the
one of them was
first
adorable.
180 days. Is that true?
Yes.
And the fact is you did not complete the 30 days in the 180 days, correct? There's also an allegation that you failed to continue your counseling with the Cancer Center as ordered. Is that true?
True with extenuating circumstances. It's not true that I refuse or I'm not doing it. As I've mentioned before, a letter was sent from the parole office without my permission or knowledge to my medical providers asking for information on my medical records. When I found out about that, I called my medical provider. They said they deleted the email. Right, this went on for about 3 months, me trying to get the email from my provider. She went to legally refused. And because of that letter that was written by the probation department and my asking about it, they discontinued service. They refused service because they didn't want to get involved in a legal case. I also went to my
Okay, so I'm going to give you and Mr. Elhart a full opportunity to explain the circumstances of these violations. But for right now, I'm just trying to establish if you're pleading guilty to this. For whatever reason, you did not complete the counseling that was ordered through Cowell Cancer Center, correct?
Correct, but not due to my circumstance, due to their circumstance.
The answer is yes.
Yes, sir.
Okay. So is it also true you were disrespectful to court employees and or service or care providers?
I was honest with them.
Okay, but would you agree that you were disrespectful to them?
To me, sir, that's a very subjective term.
Well, we can have a hearing on that issue. We can have Ms. Traska go through all of the emails and other correspondence.
I've got them too. I've got them here as well. And if you mean saying, fuck you and the horse you rode in on for writing that letter and other things like that, yes, I did.
Okay.
If you call that
What?
disrespectful, yes, that was disrespectful.
All right. So, and then it also, the allegations are also that you acted in a threatening, intimidating, and harassing manner towards other persons. Is that true?
No, sir.
Yeah.
For the purposes of this hearing, I suggest we go with the three that he's admitted to, and you can take into account whether or not you think the board is appropriate to consider for any sentence.
All right. So, Mr. Elhart, are you okay with that?
I am, Your Honor.
All right. So then, Mr. Foz, to the first three allegations, how do you plead?
Yes.
I'll accept your plea, find it is voluntary, accurate, and understanding. And Mr. Elhart, what else would you like me to know?
Thank you, Your Honor. I read the sentencing phase now, Your Honor.
Yes.
Thank you. Your Honor, Mr. Foz you received it, I think, a copy of a letter dated nearly a year ago, where he was given 2 years to live. He may not make it to his next birthday. He's under daily chemotherapy. Cancer has spread to his bones, the rest of his body, and the liver, is that correct? Lymph nodes. I'm sure that he's undergone great deal of modification to his temperament, the way he behaves, and everything else due to the cancer. I'm very certain, looking at his history and talking to him about his history, what he's done for our country, that he was an exemplary citizen. answer has changed who he is and what he is doing. His behavior is many times inappropriate. Certainly, I understand his dismay that his medical rights were violated. By the same token, I understand what was going on. He can't do any work of any kind. He can barely make it here today.
Mr. Alhart, are you aware that he was given the opportunity to consult with the probation agent to try to come up with non-physical activities that would count as community service work, such as writing letters to veterans?
I wasn't aware of that.
I wasn't aware of that either, Your Honor. That's never been proposed to me.
Right here in open court. Okay, go ahead, Mr. Alhart.
What was right here in court, Your Honor?
When we were here on the first probation violation.
This is a big deal. I'm sure you can relate to it. But there is no reason to. I'm sure that this court has seen people with cancer. I'm sure that this court has had personal knowledge of people with cancer. I have, and it changes who they are. This has changed Mr. Paz, and he's not the person he used to be. That's about all I can tell you.
Okay, thank you. Mr. Foss, is there anything you'd like to add?
Yeah, there's a lot that I'd like to add, Your Honor, but it doesn't really pertain to what we're doing here today. I've been really disappointed by the professionalism exhibited by the probation department, my violation of my rights. The scales of justice don't seem to be equal. Inflammatory language refuses, inflammatory language like that. It's not
Is this the same guy just dropped an F-bomb in court not 5 minutes ago?
accurate. It's not true. It was not, I never acted in a threatening, intimidating manner. What I do demand is service from my public employees, and refusal of service is unacceptable to me. And that has
Yes.
happened.
Big groan.
With probation, and not probation, with my FOIA requests. And when I receive pushback like that, I don't think I've made any unrealistic requests. I'm not familiar with how the legal system works, but when I am refused service, it makes me a little irritated. I expect professionalism from my public employees, and I admit I've not been professional. I've been irate, and I get that way very easily. Part of it's, as we mentioned before, testosterone is a huge impact on that. It changes your personality. I had a doctor's appointment last week, and I mentioned that to my doctor.
Oh,
And
please.
he said it's an effect of testosterone. And the reason I'm unable to perform these tasks is because of my testosterone levels, my chemotherapy, my sicknesses. The reason I missed my last appointment for probation, and I mentioned this to Ms. Trask, I wrote her a letter. I'm very sorry I missed the appointment. I was ill. I don't get my mail every week. I apologize, and I asked her if there was something I could do to mitigate the situation. I never received a reply. So it's not that I'm fighting and refusing to do what you're asking me to do. I will happily do, if I could, sir, I would happily do what you asked me to do, but I'm not physically able to do it. I've mentioned that I would be happy to pay a fine to help out the community, but physical activity serves. Yeah, I'm not.
All right. Mr. Chamberlain, anything for the people?
Your Honor, I agree with Mr. Foz that the scales of justice are not equal in this case because he was charged with a felony and could have been charged with 2 others for felonious assault. Your Honor, he got mad at someone who flipped him off. He turned around, drove his vehicle right at them, slammed on the brakes, and one of the people got hit. That person was in the hospital. They had their leg split open for, I believe it was 4 days, with a pressure bandage. So from about the top of the knee to about the top of the thigh. And that was due to his actions, due to, as he said, his anger. Mr. Elhart said, cancer has changed him. Well, then that means he's a public safety risk. Your Honor, because I ran the guidelines in this case, and had he been convicted of just what was on here, he's looking at 0 to 14 months. Had we increased it to the 2 additional felonious assaults, it would be 7 to 23 months. That's OV1 for using a vehicle as a weapon, OV2 for the potential lethality of the weapon used, OV3 25 points for life-threatening and permanent and/or permanent incapacitating impairment, OV4 10 points, serious psychological, requiring therapy and other medical intervention. OV9, number of victims. There were 2 to 9 placed in danger. OV17, 10 points for driving recklessly, disregarding life. Your Honor, Mr. Foz thinks he's the victim here. You look at his information or the emails, excuse me, and this is what he says for the victim. To be bluntly honest with you, my opinion is the legal system is fucked. My honesty lands me in hot water. Menendez, dishonesty lands him thousands in cash. That's fucked, really fucked. Your Honor, the only reason why he got a misdemeanor
Jail.
was because if it was an intentional act,
Now.
we were concerned that
I don't know what happened.
his car insurance wouldn't pay for all the hospital bills and everything else that happened. He got a gift of a misdemeanor where he needed to do community service to be done with this case. As you said, there's many non-physical activities that could be done. My suggestion, I remember at the hearing, was that he could go to a humane society and just sit and be around the animals to help, to help them essentially. Your Honor, if he had wanted to do community service, he could have done community service. He's been disrespectful to the court. He blames the court for everything. He blames the victims for his actions. I don't know what you should do, but I do know that he's a public safety risk because, as he said, he becomes irate and it's due to his medical conditions. Something has to be done. I don't know what it is, and I'm going to leave it to you to make that decision, Your Honor.
All right, so this is sentencing on a number of probation violations. Initially, the concern was fail to complete 30 days of community service work, which was intended to be in lieu of jail time, taking into account Mr. Foz's medical condition. And Mr. Foz was given the opportunity at the first probation violation. Well, it wasn't a probation violation hearing. We had a review hearing to determine how to go forward. And at that time, what I recall is Mr. Foz refused to provide any medical information of any substance so that I could even verify what his situation was and whether he was physically capable of doing community service work or not. He continued to give the probation department a hard time at every corner, even pursued them with FOIA requests asking for why his original probation officer, Ms. Hulse, left her position, FOIA requests to investigate them. And actually, my probation department, I think, protected me, or maybe Mr. Foz, I don't know, from the worst of the disparaging statements that he made about the court, about the probation agents. And Mr. Chamberlain hit on some of it. That's just the tip of the iceberg. Telling our probation agent, you need to back off and mind your manners, little miss. Thanks for really effing me in the back end. You're nothing more than a bully with assumed powers, Mr. Foz, referring to his probation agent. You asked if I would sign a release of my medical records. I refused. You lose. I will give you the letter of disability, which you didn't ask for. If you can't tolerate someone challenging your supposed authority, become a librarian. Government employees are pieces of shit, ignorant, lazy, don't do their jobs. You know, I don't care what you say about me, but you're talking to someone who comes in every day, does her job, tries to do the best that she can. And Mr. Elhart said something about, I know people with cancer. Yeah, I've got a mother-in-law who has terminal cancer right now. I can't imagine her, with as much as she's gone through the last few years, ever behaving in the manner that you have. So, yeah, that's just the tip of the iceberg. I wasn't aware of all of the
that might get taken out of
disparaging
context
statements that were made until reviewing for this case this morning.
Can you say something there?
No, it's my turn. The idea that the defendant was not able to complete community service work, as Mr. Chamberlain pointed out, is simply not true. He was given the opportunity, because of his health condition, to come up with ideas for how he would do that, including writing letters to veterans, including the suggestion of the Humane Society volunteer work that Mr. Chamberlain came up with himself, and continue to refuse to do that. He did complete 4 hours of community service work, I think at a thrift shop, maybe. So the defendant is asking to be continued on probation to complete community service, but we didn't even get into some of the threatening behavior that he engaged in. And it's a little too late. I agree with Mr. Chamberlain. I do view you as a public safety threat. In fact, we had an alert out to the courthouse because of your behavior, your threatening tone towards the clerks here, both at the prosecutor's office and the district court office. But I think what gets lost in all this, as far as what is an appropriate sentence, is what you did. And Mr. Chamberlain, to get here in the first place, Mr. Chamberlain described a little of that. Basically, you stalked these 2 guys on bicycles with your car because you felt you'd been disrespected by them. You assaulted them with your vehicle and you struck Nicholas Mendez. And this is what he said at his in his victim impact statement. Looking back on the incident now, I realized I was in shock more than anything at the time, thanks to the help of the medical team at Munson and my physical therapist. I am able to be active and attend and return to life as a student. However, the experience was much more traumatic for myself and my family than I had thought at the time. My mother took off work and flew all the way from California to Traverse City to spend time with me at the hospital following my initial surgery. She was restless and losing sleep for the week that I was admitted and didn't seem to go back to normal until I was discharged and back home. My father was the same and also came to visit me and help me around my apartment while I was recovering. Luckily, I have friends that lived nearby that were generous enough to offer their time to help take care of me after my parents left to go back home. As for myself, the summer did not play out how I imagined it would. I missed nearly 2 months of a research experience at the Rush University Midwest Orthopedics Motion Analysis Labs position that I had spent half a year networking and meeting with different professors to secure. I was really looking forward to learning about the orthopedic field and the work that was being done to improve it, but my time there was cut short by this incident. Thankfully, I was able to participate for a bit before the accident and gain some valuable experience, but not nearly as much as I was hoping for. This time was also going to be important for adding to my resume and application for residencies after completing medical school. I also wasn't prepared for how difficult my physical therapy would be to juggle with my coursework. After arrival on my first day, I was barely able to walk and I could not flex my quadricep muscle at all. We did a series of stretches and exercises that left me exhausted and sore for the next 3 days. As I was supposed to do these exercises 2 times a day, I was constantly fighting to find the time and energy to fit them in around my lectures and studying. As I progressed in therapy, the routine got easier as it would take less time and effort to complete the exercises, but there was definitely a learning curve and about a month of pretty constant fatigue. I'm lucky that that was the extent of my recovery and that I can walk and run essentially as I could before. There are still aches and pains, but it is nothing compared to the potential impairment that I could have sustained if the worst case scenario played out. It's definitely scary to think about, but I'm grateful to be where I am at today. Mr. Chamberlain is correct. The facts of this case make out a much more serious case, a felony. The defendant also left the scene after he struck Mr. Mendez in the leg. And the defendant, one thing is clear, he has absolutely no remorse for what happened to Mr. Mendez, has no understanding of his criminal behavior, and in fact continues to blame the legal system for his problems. So for those reasons,
Just as an aside, what you said, Mr. Mendez did get a civil settlement in excess, we believe, about $300,000.
okay, thank you. I appreciate the additional information. So the fact is the defendant has not learned anything from this, and I don't know what else to do. I'm at the end of what I can do. I know I'm not going to subject my staff or either the probation officer or my court staff to Mr. Faz threatening, intimidating, and disrespectful behavior anymore. So I am terminating the probation as unsuccessful. If it weren't for the cancer, I'd probably be considering a year-long sentence, but it's going to be the 60 days I held in abeyance at the original sentencing hearing. And
boom,
you have credit for 1 day served.
Go to jail, jackass.
He does not have his medication with him. Would you allow him to report?
No.
Thank you, Your Honor.
Yeah.
Ah, well, that was satisfying. Almost as satisfying as spending all morning with sloths and monkeys. There were about 6 of them. I just have this one picture. I wasn't the greatest with the pictures. I was mostly mesmerized by the sloths. I don't know if you people are aware of this. I don't know if you're aware of this, but sloths are cute. Like all of them. They had different ones that were. I made this. I was chatting with somebody earlier, and I made the same analogy, but it's true. Penguins are cute. There are a lot of different species of penguins, but all of them are cute. They look very different from one to the next, but every damn one of them is adorable. And it's the same thing with sloths. They're just the sweetest things. All right, there you have it. Thanks for coming out. Behave yourselves. You know I'm not coming to bail you out. I'm not anywhere around. And I wouldn't even if I was there. I'll see y'all soon.